So this is something that I think I've clocked something else that they're doing wrong, particularly with these claims against the police. In fact, one of the Stop ULEZ protesters mentioned, hearsay that they said, if you get arrested illegally or if the police do something to you, you might get like £80 or something. And I was like, what? £80? I'm like, that is literally insulting. That is literally insulting. £80 if the police do something to you for the emotional trauma or whatever. I mean, it's just so pathetic and ridiculous kind of payout for mistreatment, and then if someone goes and touches a kid on the leg or whatever, they end up, getting prosecuted and put in prison, yeah, if the police touch you up the wrong way, you might get, not even getting £1,000 or whatever would be an insult. Um, but that's hearsay. Now, when I first started my investigation, and I did get arrested illegally, right? I knew about my rights, but I didn't know enough about them um, to convince the police, because there's a certain amount of information that you can put on the table that they just cannot deny it, right? But when you're using, statute law and Bill of Rights and those type of things, and it's all, quite vague. They're going by modern laws and modern procedures, and they want to see modern law or modern procedure in effect, to do with all the police rules and procedures. If you just pull about statute law out saying thou shalt not whatever, then they kind of like don't take it seriously, right? And I wish I'd have had all the material that I've got now at the time, because it turns out that it's actually contempt of Parliament, and any action they do against you. This is all fleshed out. It's all intricately laid out in the manual of procedure, which I should have got. But at the time, if you approach it from a historic point of view, you find the Bill of Rights first, and then you start looking around that, and you find all the older books, like the Ancient Committees of Parliament, Oliver Cromwell, and then what you're doing is you're working your way from from back in history, learning all about what it is that, and then forward to now, right? Rather than just sort of going and getting the Houses of Parliament Manual of Procedure. Why didn't do that in the first place? Well, firstly, the Manual of Procedure is about 700 quid, between 400 and 700 quid. I think they're now selling it for about 350 or something brand new, right? The latest one. But it's expensive, and um, the new ones don't have all the juicy bits in. What they've done is they've tried to conceal and hide and sort of edit out and sort of get rid of all the juicy bits. It's almost like sort of taking the adult parts out of a film, or whatever, something like that, right? But it's not that the law hasn't changed, not that the law has removed them. It's just that they don't care to disclose it, right? Or not in as explicit terms, um, mainly because they don't want you to know about it. But when you find the older books, then it's all very clear. Now that's what you want. You want the kind of like early modern books. You want the sort of like 1800s. But even then, they'd start to say that petitions don't take up a large priority of business in the house and so forth. And then when it got to World War II, then they tried to make it even less. But you 1688, 1700, you 1700s before, because by the time you get to the 1800s, you've got the Luddite smashing machines up, and then they're not keen on people using the rights. But it was that well known that this is when Parliament burns down. But anyway, what is the point of this conversation now that I've got to do with police claims? Well, knowing all the law and knowing all your rights is important, and when you've got a substantial amount of material in front of you of law which cannot be, you just cannot, there's a certain amount. It's like in really it's like in court, how a criminal court works. They say it's beyond reasonable doubt. So if you pull out some old statute law or whatever, you could say say that it's doubtful, right? But as you add more and more and more and more material to it, and it gets more modern and it gets more clear, then the doubt recedes away, and then there is no doubt left, right? So it's almost like in a criminal trial to the standard of reasonable doubt. So then there is no doubt. So now I've got enough material that there is no doubt. Okay. In civil cases, um, you know, Black Bolt Barrister and Allen were talking about civil cases are on the law of probability, right? Which is different to based on reasonable doubt or not. Um, Now, this is the thing. So, what I said earlier on is I was talking about all these police claim companies appearing. You know that if you get arrested illegally or detained unlawfully or illegal prosecution or even arrest or whatever, you can claim against the police. Now, I wanted to do that straight away when I got arrested unlawfully, but I didn't have enough to prove the basis of my particular claim, right? Because it's a very serious, it's contempt against Parliament, and there's just no question about it. It's quite serious. It's a serious injury against you by the police. It's probably most serious that you can get, right, against someone when they're under the protection of Parliament, right? Now, when I've been reading the early statute laws, okay, uh, I when you read the first book of statutes, right? This is the Internet Archive, right? When you read the very first volume one of the statutes book, right? You come across these treble damages parts, like to do with you know, sheriff, basically, if you're executing a process or procedure and using the law, and you get actioned against or prosecuted or intervened in, right, then you can claim, right? But also, it's also got in here just illegal arrests and illegal prosecutions by the sheriff, right? But they're both grouped in together in this, right? So, if you get arrested or prosecuted whilst you're using the law or using an enactment, right, which you could say that it's in the Bill of Rights is, because you're using the seal of the crown, you're acting under the law, and it's got provisions, right? When you're using provisions of the law, it's on a proviso, it's an agreement, with the government, right? If the government says that, if you do this or that, and the legal agreement is that you can do this or that, but under these conditions, right? If you choose to use the act, you're entering an agreement really under the crown, right? As opposed to if you just walking down the road and minding your own business, and if someone kicks your car in, or if someone just accidentally damages your coat, but it's not a crime or offence, it wasn't intentional damage, but it was just like an accident, so they owe you some money, right? That's like party A and party B, but you might not have met party A, or they might not have met you before, right? So there was no kind of like agreement or contract or anything like that. It's just like someone owes you some money, or you lent some money of someone and they had to give you it back, right? Now the thing is, right, that they're definitely grouping in illegal prosecutions by sheriffs and the authorities with usage. Now, this is the thing, right? When we get to the modern law, okay, we've got the modern law and we've got this Limitations Act 1980, right? Now, there's two main types of claim, right? If you're claiming money, you've got a tort, right? Tort is a civil claim, right? And then you've got this speciality. Now, the tort basis is that you've got 6 years to claim it, right? But if it's out of that 6 years for any reason, like illness or whatever, you can ask for an extension, but you've got to get permission from the court. But a tort claim is just part A and part B. Tort really is like Mr. Smith and Mr. Johnson, right? Mr. Smith owes, for whatever reason, Mr. Johnson some money, right? Now the other type of, now this is what these new modern police claims are doing. Because when you go through their forms, right, what they're actually doing is um, they're saying you've got 6 years to claim. Now they're only going to say 6 years to claim if they're using that basis of 6 years to claim, and that's the normal tort claim, right? So they're doing it under the normal tort claim where you've got 6 years to claim. But this is the thing, right? The speciality claim, you've got 12 years to claim on standard, and obviously, you know, if you're ill health or whatever, you can get that extended. 12 years standard, right? If I'm right about this, if I'm wrong, then you know, tell me. But this is how the way that I'm reading it so far, right? Now the speciality one is it's to do with agreements. If you're under a binding agreement, but I don't know if it's only the Crown or whether it can be like a plumber. Like if a plumber says, you know, you signed an agreement with a plumber that they do this amount of work and they didn't, right? That I'm not sure if that is the speciality as well, because it brings in an agreement that was between persons, right? They've entered a contractual agreement, right? If that's speciality or whether it's just taught or not. But for sure, under the seal of the law and under the seal of the government, definitely is speciality. Now this is where you've got like the right to petition, because for sure, when you say, right, I'm going to take up and use this right, and then the government say, if you use this right, you shall not be prosecuted, right? That's the deal, that's the agreement, and that's under the seal of England. Under the seal of England, if you take up and use this right, you shall not be prosecuted. Now, if you are prosecuted, they've broken the agreement, if you see what I mean. The police, they've broken the agreement, because the agreement is that the police don't prosecute you, right? So that's definitely speciality. And definitely when it's a contempt of Parliament, in the usage of Parliament manual, it's a contempt. So that's going to be speciality anyway if it's a contempt, right? So, you know, you've got 12 years minimum time, which you can get extended. But now this is the thing. Right? In the old, in this very first law here, it's grouped in with, you know, if you're executing a function, or if you've got a usage, right, or governmental process or procedures, right. They're also saying that an illegal arrest by a sheriff, anyway, according to this, if I read it right, well, it's just there in blue, you know, treble damages. There's also a treble damages. So that, to me, in the Ancient Rights and Liberties of England, under the Ancient Rights and Liberties and Customs of England, and you know, you've got confirmation of the Charter of 1297 and all that, which is meant to keep all this in effect. According to the Ancient Rights and Liberties of England, the basis of treble damages applies to speciality and unlawful arrest and imprisonment and prosecution. It's both together. They're both together in here, right? So they will both be speciality, right? But this is the thing now, when I actually know a little bit enough to be able to make this video and talk, because if I knew nothing, I won't be making this talk, right? This is me, like, calling them out on various things, like, you know, just a minute, are they doing that wrong, or are they doing that wrong, right? Because we get these websites, right? Now, these websites, the police are breaking the law. Expert legal help, know your rights, and also, you know, they're also even doing no win, no fee. Now, there's a few companies, one of them is that Satchel Moran Solicitors in Liverpool, right? And then there's a few others. And you just say start your claim, and it's a very, very simple form. It's all set out very neat and very easy to follow. But one of the first questions is your claim, did the incident happen within the last 6 years, right? And if it didn't, they're saying they can't do it unless you send in 2 forms. I think one's an N22 form and a PF3 or whatever, and you've got to get permission from the court to appeal. They're not going to do it for you, right? But if you get permission, then they'll do it. But this means that these companies, and let's get this clear, right? These companies, right? There's no doubt people were doing claims against the police in 2013. They've always done claims against the police, right? But also normal solicitors can do claims against the police, you know, if you've been unlawfully arrested. And as I've read in the newspaper, solicitors were just going through the normal process of an interview room, and then they found out there was something being done illegally, and then they actually prosecuted the police or got a claim to the defendant. So they can do it off the cuff, a lot of these solicitors, even without being specialised. But what I'm saying is, there definitely wasn't these like tailored, streamlined, kind of like dedicated websites for claims against the police already set up like this, and they definitely weren't being advertised on Facebook, and they definitely, when you type it on Google, they weren't popping up, right? The only type of no-win, no-fee that was popping up on Google, unless, you know, someone were hiding the algorithms, I don't know, but were like, you know, if you trip over on a pavement, you know, like that type of thing, whiplash, seatbelt, injury. You know, if you've had an accident or injury, and you know the council didn't put the pavement right, or someone, you know, bumped into or whatever, then it was all no win, no fee. You know, but trying to find someone who'd do no win, no fee, so you didn't even have to put up any money. I couldn't find anything. I couldn't find nothing, because I didn't have any money at the time, and I needed to find someone who could do it without any money. But there weren't anyone, right? And now they're all over the place, right? Now they're popping up like, you know, left, right, and centre. Although there are still like some main. It seems to me like there are about 3 or 4 main companies who are promoting it heavily now, right? But they only started, I think, 2015 or 16. Now that's actually, I started in 2013, so 13, 14, 15, 16. So when I started, then these ones who are now high profile and putting it out there, they've only really been going like 16, 17, 18, 19, 20, 22, 23, 24, 25. So like less than 10 years, like, you know, between 5 and 10 years, and time's gone really quick. You know, we've had the pandemic and then so forth. I mean, when the pandemic started, they're probably only doing 15, 19, you know, like a few years, you know, 3 or 4 years. So now this is the thing, right? And this is where I don't think that I'm talking a lot of tosh, right? This is where I think I'm right, and this is the point, right? When you go on their websites, these, right, and you do the claim form, okay, they won't do it if it's over 6 years. You can't complete the form, right? Now, if it is under 6 years, you finish the form, and then they call you back, right? They get in touch with you by email or phone, but they just went a simple. They want to know, like, you know, how long was it within, and what happened, and what your contact details and things like that. They've got a basic criteria set out. Now, this is the thing, right? I don't think they're doing it right. I don't think they are. Some of these companies haven't been going that long. Now, one of them says that they've managed to claim, one of them, now this is police misconduct solicitor, right? This police misconduct solicitor, since it started business, it's claimed 105 million plus, say. I actually thought that it claimed 105,000, right? I think I misread it last time. I thought it claimed 105,000, right? But it's claimed 105 million, right? It's claimed of 105 million. I actually thought that it was 105,000, but this is since it started, so that's actually quite a lot. It's quite a lot of money, 105 million, right? 105 million paid out. But this is the thing. I still don't think that they're doing it right. And you know, what could I possibly suggest, um, you know, how could I possibly suggest that they're not doing it right? Well, because of this. Because according to how you define something, right, and what it, it actually is classified as, okay, um, it's like, um, you know, if you're talking about walking, walking's always walking, right? Running's always running. And if you're traveling, you're traveling. You've got basic classifications and identity of things, right? Now, being arrested by a sheriff unlawfully, unlawful prosecution and arrest is a thing, right? It's a thing that you identify. That is a different thing, okay, from, um, the ploughman and the farmer, um, you know, um, he owes him some money and he hasn't paid him it. He told him he'd give him it in another month and he never gave him it. So he's got to take him to court to get the money, right? That is party A and party B. Whether or not they've got an agreement or not, or whether or not he's owed it or not. Suppose that if you buy something, really, this is the thing with guarantees. You've got all these companies who sell vacuum cleaners and home appliances, and they'll say a 3-year guarantee or whatever. But if it's an agreement, and you go to court, apparently, you've got 12 years to claim, even if the guarantee is only for 3 years or whatever. And it doesn't work within that time. You've still got, if it was an agreement, under a contract, then I think you might still get 12. You might be able to have 12 years before you claim that, even if they're saying their guarantee only lasted for so long. But if there was something wrong with it, and even if it's out of guaranteed time and it wasn't your fault, this is the thing. Can you still claim against them? Can you still claim against them within 12 years? Is the whole idea of a guarantee a bit of a con? All these TV adverts with guarantees and so forth, 3-year guarantee, 4-year guarantee. Was that a con that they introduced along the way? When if you buy a product under an agreement, you got a lot longer time to claim, right? Even though the product might be guaranteed for 12 years. Maybe a product's guaranteed for longer, Maybe a product is guaranteed for longer than 12 years. Some of them might. I don't know how you'd claim after that time if the guarantee is longer than that speciality period. That's an interesting one to pose. But anyway, it's not taught. It's not a tort. It's not a civil claim between a Mr. Smith and a Mr. Jenkins or a Mr. Thompson and a Mr. Watson. According to this, right, illegal arrest and prosecution is equal to if you've been usage of an act and you get an action against you unlawfully, right? It's within it together, and that they're treble damages claims, and to me that's the same definition as this speciality thing, because usage of an act, and when it says that something shan't be done to you, you're acting with an agreement that you will be able to do this or that, and this shall not be done to you. That's the deal. That's the whole usage of it. So as far as I'm concerned, these police illegal prosecutions should be done under speciality. I don't think they should be doing them under tort. So I don't think that when they put these forms up and they're saying, was it under the last 6 years, they're using the wrong, or if they really are doing it under speciality but they're not telling you, why aren't they saying 12 years? And then why are they making you apply for a time extension when you don't need one for it? So the police claims actually should be under 12-year standard, and then you can apply for longer, not 6, and that is my claim. And the claim is that also the speciality, and there should be treble damages. Now, if they have only been doing it under the tort basis, then
have they been claiming treble damages or not, right? Or just worked out how much they're owed from, I don't know how they work it out, but from what I've heard from hearsay, from what people have been paid out from, illegal arrest, it doesn't sound like they've been given that much. Now, this company here, I don't know where I got the 100,000 from. I don't know where I got the 100,000 from. But it's 105 million plus. They're saying more than 105 million, right? Um, so that's actually quite a lot of money since the start. Between 2018 to 2022. So 2018, so 13, 14, 15, 16, 17, 18. So they didn't start doing this particular company who is now doing a lot of advertising and high profile. I've been going 5 years. In fact, 13, 14, 15, 16, 17, 18, 19. It was only 1 year before, really, my last prosecution where they took a driving license, and then that was it, really, because I couldn't really carry on the investigation. So I was doing, my whole period mainly was 13, 14, 15, 16, 17, 18, 19. It was like a 6 year period, right? So this company only started towards the end of that, and I did get to go to court, and the court, when I actually eventually got to the law that I needed for this claim, I probably could have found the solicitor to do it, or my solicitor did do it, to get the claim valid to claim, and then I had to go present it, but I didn't have anyone to go present it with because I didn't continue to use that solicitor anymore, and for whatever circumstances, I had some of the prep time, and I hadn't found that Erskine May book, but I don't think that I knew that Erskine May book because the judge should have known about it. Maybe it was the fact that, to prosecute was in contempt, and he didn't want to have to admit that he was in contempt, and that maybe why he was rather angry, so maybe he did know, but, to know what the statute law is, and it's still in effect, and you've got your documents from Parliament to prove what you're doing, it's just that I didn't have any kind of detailed writing of a modern period which removed any doubt whatsoever that this wasn't just some old ancient thing that there's no effect anymore, in a modern framework and setting in modern law, right, which I might, the manuals of the usage of Parliament are a big help. I had one lead, I had actually had the representation from Lord Hanningfield, I had that and I read it, but I hadn't clicked that really the right to petition is privileges. That it's its own separate privilege, but it's called the right to petition, but it is one of the privileges of Parliament, like the Lords, the Commons, and the subjects have got their own right. And I read the Lord Hanningfield, and not many people would have gone out of the way to get a legal paper, particularly out of something like privileges of the Lords, right? It's a bit of a peculiar article to want to pursue and get your hands on, but I got it, I asked for it, and I got it, and I read it, and I understood it. But what I didn't do is I didn't bother following up all of the citations and all of the reference material. I didn't think that was that significant, right? Because I noticed there'd been citation in the Bill of Rights for Article 9, not Article 19. But I didn't follow up the case studies, and I didn't follow up the Erskine May book. And if I did, then I think everything would have been different. But then again, Parliament don't really put a very useful version on their website, because the Erskine May they've got on their website doesn't pop up this in that they need to know when you type it in. It's not got that in it, and I don't think it would have helped even if I'd have had 3, 4, 5, 6, 700 quid to buy the Malcolm Jack or the Natzler version, but I haven't seen those yet. But we're going to find out. They might have it in. They might do, but they're very expensive, and I don't think I would afford it at the time. In fact, to buy some of those books now are about 600 or 700 quid, and that's how much I spent on the solicitor, kind of or more. So, I wouldn't have been able to just buy them like that. Although I don't know if they were online at the time. everything's online now. All these books are online, but I don't know if in 2019 they were quite online because there's a lot of things being put up on there. Particularly, even also like there's a lot of universities doing stuff. Universities um, translating stuff and transcribing things. But I had I had the right claim. Even Extinction Rebellion and Just Stop Oil haven't been doing that claim. They've just been going in and sort of messing around when they go to court or getting lawyers and just not doing the right thing at all. I did the right thing. I got my lawyer to do the correct and right claim. It's got correctly allocated, recognised, and like beep, scanned, and it was like that was an exceptional moment. But um, I just didn't have enough material to be able to follow it through without leaving any reasonable doubt. And the judge, well, he was very reasonable doubt. He said that was delusional and there was no such thing that existed, and that is a complete contempt because, firstly, it exists. To claim that no such thing possibly could exist or does exist is absolute, outright lie, blatant lie, complete and utter contempt, corruption, and that was serious. Um, but I went in there, I had my material, and obviously at the time I just didn't have enough weight on me to follow through with it. But you know, um, I think I got closer than most people have been. Obviously, people claimed it, you know, but not in modern history. I don't think that many people since the 98 since the Crown Prosecution Service started. I don't think that many people have been at the court and actually got it properly claimed and recognised, at least since the Crown Prosecution Service was started, for sure. People abused it and got it recognised that they didn't end up in court and they didn't get prosecuted, that they got let off or whatever. Um, so I was definitely on the hot spot. I was definitely in the mastermind chair. I was on the spot. I was on the front line. And my claim probably, possibly even pushing it further than some of these Extinction Rebellion stunts, which can classify as advertisements and so forth. They're a lot more easy. If you know the argument and if you know the basis, they are a lot easier to classify as being an advertisement and being canvassing, even if it's like getting into kind of like little film set or something like that for production, because at least then it's broadcast and it's still canvassing, and you are well they didn't have those arguments anyway. They didn't even have those arguments. They just I don't know. They're using all like this kind of like proportional response to this or that, which is your normal standard legal basis for when you aren't claiming rights. When you um, do an action, was that action proportionate response to something else? Was it justified action? But nothing's justified because it's a completely different legal basis and framework that you're using. But anyway, so with mine, mine definitely is speciality, and it's 12 years minimum, and it's treble damages. Now this is the thing, I actually believe that all of the illegal prosecutions and arrests are treble damages and speciality. They all should be, and it all should be 12-year claim time, but these companies are not treating it like that. These companies are treating it as they're treating it as tort, as a tort, and I think that's wrong. And if I've like when I've misread this thing and thought it was 100,000, it's 105 million, right? Definitely got it right this time. And maybe they changed it on the website. Maybe it was 100,000. Maybe by the time I took a screenshot, maybe they changed it. But I'm admitting that now. I'm admitting this, saying that I got this wrong, because I said to one of the parliamentary agents, I said, this company's £100,000, right? In terms of time, so it's actually 105 million.
So yeah, I mean, everybody who gets arrested by the police, unlawfully or illegally, it should be speciality, and it should be 12-year claim time, and it should be um, treble damages. And I don't know if they're getting them treble damages or if they're just getting them damages and working it out by what. Does it equate to treble damages? You know, the current claims they're doing now, when they say, "Oh, what happened to you? The police did this or that," you know, I had to spend, you know, a night in the cells and this and that happened. You know, they say, "Well, you know, it's about, you know, £100, £500 if you know." Do you think that it's worth £500 to spend a night in cell? You know, the traumatic damage and the psychological injury, um, you know, and the honour, and then, you know, all the costs and so forth. You know, something like that. You know, surely you look at £1,000 minimal. I don't know how they're currently calculating their um, value system on, you know, what happens to you and how that equates into a financial equivalent, right? I don't think that they're doing it under, well, whatever that financial equivalent is, right? What it would be, you know, if anyone else did it to you, you know, like if you see, you know, well, if your next door neighbour locks you up in a shed, right? That's a criminal offence against you, right? Well, that's a crime anyway, and he's going to be prosecuted. It's not a civil um, case. So I don't really know how to think of a comparison where you could say, well, you know, if someone did something to you that wasn't treble, you know, if someone locked you in a shed, for example, you know, and what damages would you get compensation for that? Then if the police do it to you, then, you know, it's 3 times more. That's what I'm trying to say. So I'm not actually quite sure um, how they're working it out. But if they're not asking you if you've got a 12-year claim time, then they can't be doing it on the speciality basis. They've got to be doing it on the normal tort basis, or they won't be saying, "Oh, is it 6 year?" Right? Wouldn't they? They'd be saying, "Is it 12 year?" So there's something not right, because that's gonna. They're like obstructing, blocking, or hindering, or misleading a lot of people who have had something done within 12 years who can claim, right? Now, who's behind these companies? Are they ex-police? Do they know the police, or what? Are these companies really that new and they don't actually quite know what they're doing, and they don't really know that it actually is a speciality? Or is it a conspiracy, and, you know, have they, you know, strategic plan to try and rip us all off? I don't know, but I'm raising this anyway. I might be wrong about it, but I don't think I am. I never for once claimed that, you know, I'm not a competent lawyer to go into a court and do claims and present a case or anything like that. You know, when I spoke to the parliamentary agent, I made a couple of mistakes which I didn't realise, but that was just some numbers I read off because, you know, well, I don't know, maybe it's been hacked, you know, maybe someone did change the number. But anyway, I'm admitting that now that I got that number wrong. But the thing is, I definitely don't think when I thought about this and checked it and checked it and checked it, like I checked this and I thought, oh, wrong about that. You know, I'm definitely checking this and checking this and checking this and checking this, you know, because I make a mistake. And I think that I'm right. I still think that I'm actually correct about this, that I'm right about it. And I do think that the police claims are meant to be speciality and it's meant to be 12 years. Now, how that affects the money and the payout of these people, I don't actually know. So, you know, that's it. I mean, Black Belt Barrister and Alan have been actually talking about a lot of things that the courts have been doing that is either wrong or questionable, or they like scrutinise it or think that it should be improved or changed. You know, so I wanted to raise this with them and see what they think. See if they think, if they check these points I've raised, do they think that you know, I found something here? Do they think that I've found something that these claim companies might be using the wrong, at least the wrong claim time? and the wrong compensation scheme. You know, if they, I definitely think they're using the wrong claim time. I think that they're using the wrong claim time. Now, if I'm wrong about that at a later stage, I'll make a video and say I'm wrong about that. I got this number wrong. It's 105 million, right? It's not 105,000, right? Although, um, you know, so I'm admitting that I read that number wrong. But I definitely still think that they're asking the wrong number when you go on the website. And if they are using the tort basis, it won't be treble damages, I'm sure. Unless you can get treble damages on the tort. But if they're using treble damages on the tort, then why aren't they giving you the 12 years to start with? It seems strange to me. So, you know, I'll tag Alan and I'll tag Black Belt. I don't know if they've got time to listen to this or anyone or whatever, but you know, this is just my current this is my current basis of this.